Namaste. Telugu Prajala Mana Sakshi TV. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Prashanthi Reddy from the Law Office of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy, and on Friday at 6 p.m. EST with Banu Ilendra. Please tune in to ask your questions. If you have any queries regarding immigration, please feel free to call us. Our attorneys would like to answer your questions. If you are an immigration attorney and would like to join us in our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note down the information provided in this show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents are not responsible for the use of this information. If you need a special legal advice, please contact attorneys directly. Today, we are going to talk about alternatives to H1b visa. For that, we are here with our attorney Prashanthi Reddy. Without any further delay, let's start our show by welcoming Ms. Prashanthi Reddy. Hi, Ms. Reddy. How are you?
I'm good, thanks. How are you, Swarna?
I'm good, thank you, and welcome to the show.
Thank you.
Ms. Reddy, can you please provide the information on your law offices, practice area, and your experience?
Yes, I practice immigration law, as you all know. My offices are in Midtown Manhattan in New York, and you can find out more information from my website, reddysq.com.
Awesome. So, viewers, if you have any questions and would like to reach out to Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddysq.com. So, Ms. Reddy, H1b alternatives, what are the available visa options for that?
I think we started discussing it last time, but we were not able to, get into it in depth. So I think we should just start. I think we just started talking about it, but we had so many calls that we couldn't discuss it in depth. But now that the H1 cap season is over, in the sense that the registration took place in March, and it was picked immediately in March itself. By April 1st, all the H1s were open to be filed, and the last date to file H1s was June 30th. Just giving you an update on the H1s first, and then we can talk about alternatives to, now that the cap is over, giving you an update on the cap. So June 30th was the last date to file H1s, and then recently, last week, they had a second lottery, and there were some cases picked in the second lottery as well, quite a few compared to last year, I would think. Compared to last year's second time pick, I think there were more picked this year. So there were more numbers, I guess, available compared to last time, which means more people registered but didn't file. So there might have been a lot of duplicate filings, is my guess. And again, they have 90 days. Employers have 90 days to file the picked petitions. So, November, the cases have to get filed. Before November, so, end of October. So that's the update on the H1b cap petitions. And now that, if there are any new cases that have to be filed, obviously we cannot file them. So if there are employers looking to hire foreign employees, then they have to either they have to wait until next year for again the registration to open up, and then by the time the case gets filed, and the start date for any new H1s would again be October of next year, if the registration is done in March. So it's a long wait, more than a year, right? So we have to look at alternatives to the H1b, so that we can cover any gaps, any needs by employers in the meantime, between now and this next registration, start of the next registration. So the first thing to keep in mind is, of course, we have a lot of employers qualify for cap-exempt, which means that they don't have to file their H1b petitions during the cap. They can file them at any time. And these petitions are basically institutions of higher education or related or institutions that are related or affiliated to a higher education institution, or a non-profit research organization or a government research organization. So if your company is one of those, definitely you can file. But for a lot of the IT people, where they're working for consulting companies, but their end clients may qualify as one of these cap-exempt organizations, please remember you can file also under cap-exempt as long as you show that your end client is cap-exempt. So for those of you who are frustrated with not getting picked in the cap year after year after year, it might be a good idea to find end clients who are cap-exempt. A lot of you work for governmental research organizations, you work for universities, you work for hospitals. So, any cap-exempt, that can solve your problem if end client is a cap-exempt organization, and then we can help you file. Or any attorney, good attorney who has immigration experience can help you file that H1b petition for the cap-exempt organization. In addition to this, we also have O visas. O visas are generally, so this is the alternative to the H, and of course not everyone qualifies, but some do. So O visas are generally reserved for individuals who have an extraordinary ability. So you could be on a H1, but you might have an extraordinary ability. You might be working for an employer, but you might have an extraordinary ability in the science or in the art, and you might be able to use that and file for an O1. For example, you might be a scientist, right? As a scientist, you would still file a H1, but it's possible that because you would qualify, that's a minimum qualification. But it's possible that you may qualify for an O1, or you are a doctor, and you're doing research. You could qualify, as an extraordinary ability in the sciences, or you are working on a H1, but maybe you qualify in the arts, right?
Yes, Reddy. We have
Yes.
a caller. We have a caller from Texas. Srinivas from Texas. Hello.
హాయ్ ప్రశాంతి గారు, నా పేరు శ్రీనివాస్ అండి.
చెప్పండి
సార్, మేడం, EB2 అప్లై చేశారు మా కంపెనీ. ఫామ్లో ఒక రోల్ ఉంది, లైక్ బిజినెస్ సిస్టమ్ స్పెషలిస్ట్ అనే ఉంది ఫామ్లో. సో దే అప్లైడ్ EB2 in business system specialist like back in 2013. Now we want to downgrade to EB3 based on the form that's been done before. So what is the role should be? Can it be my new role, or it has to match with the previous role what is there in the form? Does role play any role when
role plays a big role? The
Okay.
role plays a big role because you cannot change the role when you're filing the remember, you're filing it on an existing perm. If all the parameters are already set in the perm application, you're not filing a new perm, right? You're just filing a new I-140. But you have to follow all the criteria that is already mentioned in the perm and in the advertisement. So you cannot change anything. It has to be exactly the same, in the I-140 application.
My current role is the team lead actually. So does it matter like what I put on the I-140 when I do the EB3 downgrade?
Well, your employer has to be willing to offer you the role that is in the perm application. That's the meaning of the filing of the I-140. That's the meaning of filing a perm. It's an offer of permanent employment in that particular role, whatever role is mentioned in the perm application. So they have to be willing
Yes,
to
ma'am.
offer you that role, right? So they have to be willing to file the I-140, fill out the forms. The forms have to be filled out as per the job title in the perm application. The offer of employment has to be given as per the letter in the job title in the perm application. So everything has to be done as per the perm application.
But ma'am, I'm in a better role actually. Right now, I'm in a team lead
Doesn't
position
matter. Then
because
file. If you're in a better role, then refile your labor cert in that better role and refile your I-140. No one is stopping you from doing that. You understand?
right, ma'am. But the thing is, like, historically Indians have been backlogged, right? And
Correct.
I might have applied it in 2010 with a role, and USCIS cannot
Yes.
and
So you
expect the
have to go
same
to
role
Congress.
after.
Yes, I understand completely, but then you have to go to Congress with your grievance. There's no point in going to
Makes sense.
USCIS because they will follow what the rule is, right? They cannot change the rules, correct? And
Right,
I, as an
right.
attorney, I am telling you what the rule is. Yes, it is not
Got it.
ideal.
Got it.
Yes, I agree with you that things have to be changed, but you cannot go and write a letter to USCIS saying, I've been waiting for 10 years, I want to change the rule. Then they'll say file a new perm.
Makes
So
sense.
we have to live with what we have and follow the rules that we have right now.
Yes, ma'am. Ma'am, my priority date is August 2012. Do you think, like, shall I wait for the October bulletin or shall I EB2? Shall I wait for the October bulletin or shall I downgrade now? And what's your opinion, ma'am?
So if you're eligible now, you should file, and then you can always, interfile. You have to. So if you downgrade now, you're filing a new I-140, right, to EB3,
Yes.
and you're then as soon as the date becomes current, you will file the 485.
In EB3,
So
my
nobody
date
can
is current
say,
already.
right. So you said 20. What did you say your date was? 2013?
2012 August.
2012. Okay, so then you should immediately file. Why are you? Would you rather wait for, if you have one bird in the hand, would you rather wait for the two birds in the bush or act on the one bird that you have in your hand? Logic, right?
Yeah.
This is just logic.
Yes. Yeah.
This is not immigration law.
Right. Right. No, my employer resisted so far, and finally he agreed. So, but it's almost close to
You should
October.
do it.
So,
You should do it because you don't know what will happen in October. You don't know if the dates that are presently there will move backward or forward. You don't know anything. So you do
yes,
not
ma'am.
take a chance. You've been given an opportunity. File it. Then afterwards you can always upgrade, downgrade, interfile, do 100 different things, right?
Okay. Makes sense.
In October, if your final action date for EB2 becomes current, you have an EB2 already. You're not filing an amendment of the I-140, you're filing a new I-140. So if your EB2 I-140 gets current in October, final action date, then you can just use that I-140 and interfile, right? Whichever
Okay.
is better. You can use that. If the dates for your EB2 become current, you can use that. Because you'll have two
Got it, ma'am.
I-140s
Yep.
at that point.
So, is interfiling a hectic process or is it a normal process?
Usually USCIS is supposed to do it automatically, even without us asking for the interfiling. They will just use the I-140 that has the best priority date and process the 485, provided it's with the same employer that has filed your 485. They're supposed to do it automatically. Whether they will do it, not do it, there's no reason not to do it, but sometimes yes, it can take time. But if you have the opportunity to file now, not filing it and looking for something that might happen in the future, it makes no sense to me.
Awesome. Thank you, Mr. Srinivas, for calling us. So, Ms. Prashanti, would you like to continue our alternate visa options?
Yeah, so we were talking about O and also P visas. So as I said, this was for people who have an extraordinary ability in the arts, sciences, television, motion picture industry. So you might be an IT person, but you might have you might be a director on the side for a movie. That's possible. I've filed O's for so many people like that. So there's always your hobby that might become, in this case, a pillar, yeah, for your immigration case. So you never know. So it's extraordinary ability in the sciences, arts, television, motion picture, education, business, or sports, athletics. So maybe you are an acclaimed business person and you are here on a, you are on a H1 working as an employee for now. But you're well known for whatever something that you've done in the business world. It could be anything really. So I agree that not many people by definition would qualify for an O. But it's something to look into, especially if you're bringing someone, the employer is bringing someone from outside the country. Also, there's a P, remember. The P is a performer visa. So if you are someone who does a performance, who sings, who's a dancer, maybe he or she is acting in a play, any kind of stage performance is a P. So you could bring them on a P and then, convert it to a H1 after that. Also important to remember that these type of people who qualify for an O usually qualify for an EB1 category. So the green card, the EB1 green card, which is current. They'll qualify for, extraordinary ability EB1. So it's important to keep that in mind and keep all your options open. And though O and P is difficult because obviously only the cream of the cream will get that, something to keep in mind and not forget about. The other option also that you have, which is more doable, is the L1 option. So if you're on a H1, you're talking to the employers right now. I mean, if you have an employee on a student on an F1, and you're not able to convert that person to a H1 because he's not getting picked in the cap, or for that matter, you need someone who is working with you in India, you need to bring them here. You missed the opportunity to bring them here because they didn't get picked in the cap, or you didn't, have that candidate available at that time. You want to bring them now as your employee, but obviously you don't want to wait for a year and a half. L1 is a really good option in lieu of a H1. The reason I say that is because if the person is, for example, there are two types of L1s. One is an L1A, which is a multinational executive, and the other one is an L1B, which is basically someone who has specialized knowledge, of your company, the processes of your company. That's an L1B. So an L1B, so for example, if you have someone working as a project manager, say, just sticking to the IT space because it's easy to give examples, that person is a managerial level, so qualifies for an L1A. So if that person has been working heading projects in India, you want to bring them here, you don't have to wait for the H1. You can bring them on an L1A as long as they've been working, for a period of 1 year in India. And this is, of course, presuming you have an office in India and you have an office here, and the employee has worked in the India office for 1 year in a managerial or executive position. You can bring them here, and the fabulous thing about an L1A is that it's EB1. So you can file for a green card, and it's current. So they'll get the green card very quickly. The other category in the L1 itself is the L1B category. So even if they're not working in a managerial or executive position, but say you have a project that employee has been working with in India, and that same project has to be implemented at the client site here in the US, that's a perfect candidate for L1B because, they have specialized knowledge of the project, and that's how they qualify for an L1B. L1B, of course, you have to file a regular labor cert, and they don't automatically qualify for the EB1. For L1A, you don't have to file a labor cert. They qualify for EB1, so you can file an I-140 and a 485 right now directly. So that's something to keep in mind. Also, the additional benefit for the L1 category is that the family members get to work on an L2 status. Unlike the H4 EAD, which only some H4s are allowed to work on, dependent status, for L2, all L2s automatically are, allowed to work. So that's a great option to be in, I think. Of course, there are a lot of documents required for an L1. It's not as simple as a H1, because you have to show that your company, first of all, you have to show that your employee was in a qualifying position back in India or wherever he was abroad, wherever your company is located. So you have to show not only via a job description, but you also have to show documentary evidence that the person was in a particular role, in a qualifying role. For example, if the person worked as a manager, and if the person you're saying managed 10 employees, you have to show that, documentary evidence that the person signed off on the employment letters of those employees. I guess the person did a review of that employee's work. The person supervised those people, emails back and forth. If the person was in charge of a department, manager of a department, then you have to show that, they were authorized to make certain decisions on behalf of the company. They signed off on certain documents. Email correspondence showing that they made contributions to the policy of the company. There are a lot of documents that can be submitted, but documents have to be submitted showing that they qualify for that position, L1 position. They qualified even when they were working in India or abroad. Also, you have to show that there is a relationship between your US company and India company. Meaning you have to show that the relationship is that either of a subsidiary or you have to show that it's a parent company. So the relationship is that of subsidiary and parent, or they're both associate companies to each other. Or one company is a branch to the other company. So that is shown through share certificates, etc., to show who the owners are. So if it's a subsidiary and parent situation, then the owner of one company has to have the controlling share of both the companies. So there has to be one person that has controlling share of both companies, right? So that's the parent and the subsidiary. Or the parent company has to own all the shares of the subsidiary company. So you have to show in a shareholder certificate that that's who the owner is. The other thing you have to show is also that it's an ongoing business. Your company back, the foreign company, is an ongoing viable business, which means then you have to show your tax returns, your payroll records, your lease of your office, or if you own your office premises, you have to show ownership documents, registration documents, incorporation documents, proof of business other than tax returns, invoices, client contracts, list of clients, whatever it might take to show that, brochures, marketing material. You also have to show that your US company has a need for this person here. What is the purpose of bringing that person here? You have to show that. You have to document that. For example, if it's a manager you're bringing here, maybe he's coming to open a new office. Then you have to show a business plan for your US company to show what your expected revenues are, if it's a startup especially. Where this person will function, where he'll be situated in the org chart, who will be reporting to him or her, who that person will report to. So there are a lot of details that go into, filing an L1. And it's becoming more and more difficult in the sense that we're getting a lot more RFEs for L1s, where they're asking for proof that the person is actually working worked in a qualifying position and will continue to work in a qualifying position in the US. For example, if you say the person is a manager, and if you don't have any employees in the US, then who is he managing? How do you justify that? So it becomes more difficult then. Then you have to use other criteria to show that he's a manager. You have to show that he's managing processes, not people. So, then it becomes, there's one level of complexity added when that happens. So that's about the L1, but very useful if you qualify because of the EB1. And if you're able to show all this, not very hard to do. And L1 is for 7 years. First you get it if your US company is a new company established less than 1 year ago, then you get the L1 for a year, and then you can extend by 3 years and then another 3 years, total of 7 years. If your US company is established, that means more than a year old, then you can get straight away an L1 for 3 years. Then you can file an extension for 3 years and then again 1 year. In the meantime, we're presuming that if the person has stayed here that long, they will, file for the green card. As I said, the L1A especially goes into the EB1 category for multinational executives. And you're qualified to file directly the I-140 after 1 year of that person being on an L1. So that's the criteria for filing the green card. So in addition to the L1, there are also other categories, and these categories are really country specific, which means only people from certain countries are eligible for those non-immigrant work visa categories. So one of them is the TN. The TN is open for Canadians and Mexican nationals. And it is only open for certain occupations. And if you want to see the occupations, the designated occupations, for TN and Mexico, there is a document which is available online, and you have to look at those list of designated occupations and see whether that particular job that you want to hire your Canadian citizen, Canadian national or Mexican national or citizen, whether it falls under one of those occupations. For example, I believe systems analyst, software engineer, these are occupations designated to qualify for a TN. So it's not like a H1 where you have to show where it's open-ended, where any occupation qualifies as long as a bachelor's degree in a specific field is required for that occupation. For a TN, you don't really have to show that a bachelor's degree is required. You just have to show that that occupation exists in that list under NAFTA. It's a list that's available on the NAFTA website. So as long as that occupation is there, you qualify for a TN. You don't have to show anything further, period. You don't have to show bachelor's. You don't have to show that the duties are complex or specialized, nothing. So that's one advantage for the TN. The other big advantage is that you don't have to file a petition, an I-129 petition, with the USCIS. So the person can directly go to the port of entry, which means they can fly to or come by road to the border, and there they can show their documents and request for the TN visa. So you don't have to have an approval from USCIS before. And neither do you have to go to the consulate for a visa. So you can just apply at the border. So that's a huge, double plus, because no consulate, no USCIS. It's only CBP at the port of entry. They will decide whether you can come in or not. So once you're in the US, of course, if you're in a different category and you don't want to travel, for example, now with COVID, the land borders are closed, though the airports are still open. Some people don't want to travel. So they want to file for a change of status, say from a H4 to a TN or a B2 to a TN visa. In those circumstances, if you don't want to travel and come back, then you can file a change of status. In that situation, then you'll have to file the I-129 application, the same form that you filed for the H1 with USCIS. And once it's approved, then of course you can go ahead and start working on a TN. Also for a TN, there's no automatic path to a green card. So that's, unlike the L1, that's a disadvantage. The other country-specific visas are visas for Singapore and Chile. That's the H1b one. And then the other one is the Australian visa, which is the E3. The E3 is the for Australian citizens, and these visas are the big advantage of the E3. H1B1, by the way, has a cap, but it never gets met, and it's the same criteria as H1B1, H1b, except that it's for Singapore and people from Singapore and Chile. Now, the E3 is for Australian citizens, and Australian citizens may be eligible for E3 visa. Now, E3 is not subject to the cap. And so there's, you don't have to worry about the cap getting over. And the good thing about the E3 is the criteria is the same. Again, you don't have to file for an I-129 at the USCIS. You can directly file for an E3 petition at the consulate, though, not at the port of entry, but at the consulate. So a person can go to their consulate in Australia, the US consulate in Australia, if they are an Australian citizen, and apply for a E3 at the consulate. The criteria for E3 is pretty much same or similar to the criteria for a H1, right? So you have to show the same specialty occupation, and you have to show that the person has a bachelor's degree in a particular field, and that the job requires that they have a bachelor's degree in that field. Or if a bachelor's degree is not required generally in the industry, you have to show that your particular job is so specified that a bachelor's degree is required, is so specialized, sorry, that the bachelor's degree is required. So you have to show that the duties are complex in order to qualify for the E3. The other criteria is the E1 and E2 treaty trader or investor category. The E1, E2 visas allow nationals of countries which have trade treaties in the US. So not all countries are eligible for the E1, E2. Again, that is country specific. The E1 is the treaty trader designation, and the E2 is the treaty investor. So the treaty trader, and again, as I said, not all countries qualify. For example, India is not in that list. So the E1 treaty trader visa is suitable if treaty trader is suitable if the foreign national has a multinational employer who is willing to transfer them and form the foreign company to the US, and the company has significant trade going on between the foreign country and the US. So this is slightly different from the L1 because it's not required that there be a company in the US. It's just required that there be significant trade between the foreign company and the US market. So that means they have a lot of US clients, and they're trading goods or materials or services with those US clients. And this person needs to come to deal with those US clients. Obviously, the person who's coming in must have the skills which are essential to the operation of the trade of the company. Meaning he cannot have software skills. because that's not the purpose of him coming here. The purpose of him coming here is to trade. So he should have skills related to, trading. And the good thing about the E1 is dependents of an E1 are eligible to work in the US. So that's a big plus, right?
Yep.
Um,
So thank you, Ms. Reddy, for explaining about alternatives of H1 visa so well. So viewers, if you have any questions and would like to reach out to Ms. Reddy directly, you can call her at 212-354-1010. Extension is 107, or you can email her at prashanti@reddysq.com. So, Ms. Reddy, what about automatic waitlist and second chance lottery in summer?
So should I just finish the E2 first? I didn't finish the alternatives as yet, actually.
Okay, sure.
And then once I'm done with the alternatives, then of course, we have to go through the F1. And then, of course, we have to go through the green card process, because that's also, an alternative. So we have some more alternatives left.
Okay.
And then if we still have time, then we can go to the, the next questions that you have. Does that sound like a plan?
Yes.
Okay. So E1 is what I was talking about. And in between, you can give me a break. If I'm talking too much, you can take over.
You're good.
So the other option is the E2. And the E2 is basically a treaty investor visa. So treaty trader, treaty investor, E2. So treaty investor visa allows foreign nationals to invest preferably a substantial amount in the US, and so that they can obtain that E2 visa. And they will, basically the E2 person, his or her role is to manage that investment. So it's a little different from the EB5. Unlike an EB5, there's no minimum or maximum quantity that has to be invested, right? There's no criteria like that. There's no criteria that so many employees have to be hired. This is the amount of investment. Those criteria are not there. You have to invest. It just says substantial amount. Substantial amount meaning sufficient amount to run your business. It depends on what business you're running, right? Maybe some businesses require only a few 100,000, and some require, millions, depending on the type of business, the amount of investment. So, as I said, the amount required for investment generally varies depending on the interest rate. It's a so-called proportionality test. So what they're looking at here is that how much of it have you invested? So obviously more capital will require more investment. But have you invested enough to start the business? Have you invested 50% of that? For example, I'll give you an example. For example, if you are coming to the US to, say, buy a business, you're buying this restaurant, and the person who is selling it for 200,000, say. It's an already existing running business. So say you invested only 10,000, and then based on which, you're self-employed, so you're coming yourself, you're the person doing the business, or your employer is sending you here, whatever it might be. 10,000 is not a substantial amount if the total capital is 200,000, right? So you should at least invest more than half of it. There's no rule, it just says substantial amount. But the more upfront investment you make, the better, the easier it is for your case to get approved. You make 200,000, even better if you make the total investment required. So it should be either the total or at least a substantial amount of the investment. So that's the E2 for you. And there are several conditions for the E2. You have to show the source of funds. It cannot be an illegal source. So there's a lot of different criteria. You have to show the path as to where the money came from. You have to show proof that it was actually invested. or it's in the bank account, of the company, and you have to show how that money is being used. If it is not already used, then you have to show the plan. If it is used, then you have to show, you have to prepare a chart to show what money went where. The other advantage of the E2 visa is that they are eligible to, the dependents are eligible to work. So as you can see, most visas dependents are allowed to work except for the H1. And that recently they have made some changes, but in my opinion, not enough. So the next option, of course, is your F1. When students don't get into the cap, they often go for, they go for another master's degree, or they go for an F1, and then they apply for CPT, which is Curricular Practical Training. So although employment is not the main goal if you're a student, and that is not the purpose of taking the student visa, it is an ancillary benefit of being a student. So you get the benefit of getting an OPT after your course is completed, provided the course is at least for a duration of 9 months or more. Or you get something called Curricular Practical Training, which you can take even before your course is completed, provided that the university requires that you take requires it because they're teaching certain subjects that requires practical training simultaneously. Of course, in that situation, the university has to actually show that which courses and which courses need the practical training, and you also have to show your employment and the job description to show how the job is actually related to the courses that you're taking. So that's CPT. OPT is optional practical training, which is you get 1 year of OPT after you complete your F1. So these are again means of working, and a lot of people work and study simultaneously by taking CPT, and there's a lot of controversy about taking first day CPT, which basically means they start college and then they immediately take up CPT. So that's well known in the industry that especially the students who have not been successful with the cap continue to be students by taking one course after the other, one master's after the other, and continue working even after their OPT is over. So what they usually do, the trajectory is they do a master's. If it's a STEM, in the sciences, engineering, math, then you get 3 years of OPT, optional practical training. But sometimes that 3 years of optional practical training is not enough to get picked in the cap. So then they do another master's program, and then they take CPT in a month or the first day or whatever. So they continue to do that job that they were doing previously and work. And usually the classes are on weekends, so they continue to do both. And often people who have taken CPT, they are, when they file for a H1, there are questions about whether they maintained their status, whether CPT was valid. So there's a list of questions usually asked in an RFE, in a CPT-based RFE, and they want to see whether they've met the requirements for the CPT. So that's a very, very common RFE that we get. Most cases do get approved if they're able to submit all the required documents and if it was a legitimate CPT program. So so F1 is definitely a huge a way that people use to to work in lieu of H1 or some other work visa. So after the F1, of course, you have the green card, right? You can obviously work on a green card. So it doesn't have to be a non-immigrant petition that you're working on. In lieu of the H1, you can directly file a green card. In a lot of countries, the dates are current. Maybe Indian nationals, not all dates are current, only EB1 is current. But for other nationals, EB2 might be current also for worldwide. So employers can directly file a green card, say, as long as they're not looking for Indian employees. Indian employees, as I said, only EB1 will work, which we talked about, the multinational executive or extraordinary ability. If you're EB1, then the employer can file a green card directly for that employee and get them in a year or so, provided, everything goes as planned. But this is possible if you're hiring people from other countries where the visa numbers are not backlogged. You don't even have to. Why care about getting them on a H1? And especially with the cap, you can just get them directly on a green card, and they can be at your doorstep in a year or so, provided there are no backlogs, of course. Now with COVID, everything is so backlogged, especially immigrant petitions. But in general, this is a good way of getting people into the country. Just file the green card for them. So do the labor cert, get the I-140 approved, and then file an immigrant petition. Then they go to the consulate, apply for a visa, and then an immigrant visa, and then they come into the country, and then the card is actually processed when they come into the country. So they're coming in on a green card. So that's actually a really good way that a lot of employers overlook the green card process. But of course, as I said, there's a huge backlog for Indian nationals for EB2 and EB3, so that's not possible unless you're looking at, getting an employee 10 years from now, which makes no sense because business requirements always change. But you can definitely get a EB1 person if you're an Indian national. From India, you can get an EB1 person who qualifies within a year or so to come in. So, that's something that, again, is important to keep in mind. So another hope is that, and there's always an eternal hope, that the H1b program may be changed by Congress, and that they may increase the numbers or they may remove the cap. It's unlikely that will happen given the current scenario, but but there's so much, you never know, right? Because things can change overnight, so you never know. Maybe there'll be some new law which can help, and then we can get the benefit of it and file H1s throughout the year. It's happened in the past. They've increased the cap during Clinton's time, I believe, to 110,000, if I'm not mistaken, 125,000 from 65,000. So that's, they more than doubled it. So that's possible if they're, willing to increase the cap. Of course, if everything else fails, then you have to wait until March of 2022 to file a new cap subject petition. Also, there might be an exception, meaning that maybe you're not cap subject. So there are some instances in which people are often confused as to whether a person is cap subject or not. Now, if you have been counted towards a cap before, right, and you have left the country and you're away for a year, 2 years, say you're away for less than 6 years, then you can come in and you don't need to wait, you don't need to file under the cap. You're cap exempt. So it's important to know who's cap exempt and who is not, right? So you could be just cap exempt. But again, it worked the other way around, is that you could be filing for a H1 under the cap, but it could be that it got approved, but you never actually used that H1. You never worked on a H1. And you might think that you can file a petition next year through a different employer, and that will be cap exempt. So that's not the case. You will not be cap exempt in order to be cap exempt, you actually should have worked on that H1, and that's the strictest interpretation which they're following right now. And you should have worked within the last 6 years on that H1. So if you meet those two criteria, you're cap exempt. Otherwise, simply getting a H1 approval, you will not be able to file another H1. You can use the same H1 if that employer still has the job open for you, and go to the consulate and apply for a visa using the same H1, but you cannot file a new H1 as you are, from a different employer as your cap subject. So I think we can go into more detail if needed, but I think I've covered at least the bird's eye view of the alternatives to a H1.
Yes, Ms. Reddy. But is there any other alternatives to H1b cap petitions?
No, only the ones that I mentioned.
Okay. So viewers, if you have any questions and would like to reach out to Prashanthi Reddy directly, you can reach out her at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. So what about cap exempt H1b?
Yes, we discussed cap exempt H1b, right?
Yeah. So that's like, you have anything more would you like to share?
No, I think I've pretty much covered the cap exempt. You are either the employer is cap exempt based on what I just said, or the beneficiary is cap exempt. That is, the employee is cap exempt because they were counted towards the cap before. Also, there could be a situation where you're cap exempt. So I can give you another example. It could be that you spent 6 years on your H1 and then you left the country, and then you filed for a green card, or maybe a green card was pending when you left because your 6 years got over. And then after you leave, your I-140 gets approved, then you're eligible, as you know, for beyond 6 years limit. You're eligible to file for the H1 beyond 6 years. In that instance, you're still cap exempt because you were counted towards the cap and it was less than 6 years when you were on a H1. But for example, if you are not cap exempt, if you leave the country and you've been out of the country for a year and you have no I-140 approval, so based on the rule that there's a rule that if you are out of the country for 1 year, then you get a fresh 6 years on your H1. So based on that rule, if you come in and seek new 6-year term, then you are cap subject because you're seeking a new term. This is important to note. You're not cap exempt because you're not seeking extension based on I-140 approval. You're seeking further time. You're seeking a new time, new 6-year limit on your H1, and when you seek a new H1 limit, a 6-year limit, new 6-year term, cap applies. So you're cap subject then. You can't say that you're cap exempt. But if you've been out of the country for more than a year, but you're not looking to use that rule of being out of the country and getting a new 6-year term, you're maybe coming back based on the remaining time that you have. Maybe you didn't use all 6 years on your H1, or you're coming back based on an approved I-140, that different rule, then of course you are cap exempt. So there are many issues about who is cap exempt and who is not cap exempt.
Yeah.
Many examples can be given.
Awesome. So, Ms. Reddy, what about like O1 or P1 extraordinary ability visas? What are these?
What about them?
I mean, we like to know what are the O1 or P1 extraordinary ability visas.
We discussed that, no, already? O1 and P1 extraordinary ability. We talked about extraordinary ability in the arts, extraordinary ability in the sciences. So we've discussed the O's and P's as well. So if you don't have other questions, I can talk about H1b Rfes, because the natural progression of what happens after H1 is filed, and once the H1 is, cap exempt is closed, is pretty much Rfes. Once you file the H1, what is the next thing for the employer to expect? It doesn't have to be an RFE, but this is the time when RFEs are coming. So maybe that is something that we can, talk about briefly, because I know we don't have much time. I didn't want to get into a new topic, but we can, so we are seeing a lot of H1b RFEs now that the cases have been filed. Not as much as, of course, we saw in 2018, 2019 during the previous administration's time. Now, most of the RFEs that we are seeing is student. So if it's an F1 to a H1, we're seeing a lot of student RFEs. I was talking about the CPT RFEs that we get. So you basically get an RFE saying that prove that the person has maintained valid student status, prove that they have used the CPT program properly and not violated their status, and that the college actually requires CPT and they meet all the essential elements of CPT. And if they were on OPT, then if they were previously on OPT, then move to CPT, or vice versa, then they might send an RFE on both questions of whether they maintained OPT or not and whether they maintained CPT or not. So OPT is they want to make sure that they worked, so there are certain requirements for OPT. You have to work a certain number of, only certain number of months, I think 90 days is when you can be without a job in the 2-year extension OPT period. And during the first OPT period, which is the first 1 year, so first you get OPT for 1 year, then you get an extension for 2 more years if you're a STEM. That's called the STEM extension. So the first year of OPT extension, it doesn't have to be paid employment, but there has to be employment. You cannot show that you did not work. If you're saying that you didn't work, then you're not maintaining you should leave the country. You shouldn't just stay there doing nothing. So if you just stayed without a job, even if it is a voluntary job, then you're violating your status. And since you have no proof that you worked, your H1 will not get approved because you're asking for a change of status. So you have to show that you're in status in order to get that change of status approved, right? So that is going back to the OPT. With reference to CPT also, you have to show that you worked in a job related to your courses. For example, if you're doing an MBA course and you worked in an IT position as a software developer, obviously there's no correlation between the course that you're studying and the practical training that you're getting. So you don't fulfill the CPT requirement.
Yeah. Sure.
So, your H1 will get denied because you did not meet the requirements.
Yeah. Sure. So thank you so much, Ms. Prashanti, for explaining us all about H1B alternatives. So viewers, before we wind up, if you have any questions and would like to reach out Prashanti directly, you can reach out to 212-354-1010, extension is 107, or you can email her at prashanti@reddysq.com. So this is Swarna signing off. You're watching Telugu Prajalamana Sakshi TV. Namaste.